Hello friends, in the series on the income tax cases, today we will discuss a very important issue on the registration of the societies, trust and various type of NGOs under section 12AA. As all we know that the matter of registration goes to the Commissioner of Income Tax Exemption, and the Commissioner of Income Tax Exemptions under section 12AA subsection 1 clause B has the power to review the objects of the society. There is a difference between the word objects and activity. The objects are narrated into the bylaws of the society, and actually the advancement of those objects represents the activity of the society. So the question which has been taken by the Orissa High Court in the present case was that whether the Commissioner of Income Tax Exemption has the power to review both the objects and the activity of the society at the time of granting the registration. This issue has been taken up in the case of Commissioner of Income Tax Exemptions versus Orissa Cricket Association. This case relates to the assessment year 97-98 and assessment year 2011-12, and the case has been reported in 461 ITR at page number 382, and the date of the judgment is 13th July 2023. In the present case, there was some survey search on the assessee in which some material was found, and the department came to know that there was some diversion of the funds towards the executives of the society. On the basis of that information, when the application was pending before the Commissioner of Income Tax Exemptions for the registration, the Commissioner of Income Tax Exemptions gave its view that the funds of the society have been diverted for the benefit of the executives of the society, and the learned Commissioner of Income Tax Exemption was also of the view that the assessee has received some funds from the BCCI, and the assessee has directly taken those amount into the corpus of the assessee in spite of treating them revenue. Basically, whenever the amount is transferred directly to the corpus fund, the condition of doing expenditure of at least 85% does not apply. So this was the viewpoint of the learned Commissioner of Income Tax Exemptions. Apart from that, the contention of the assessee was that Commissioner of Income Tax Exemption has only the power to review the objects and not the activity of the society. The assessee was contesting on this point. And another submission of the assessee was that the provisional registration has already been granted by the revenue to the assessee for the assessment year 22-23 to 26-27. But the Commissioner of Income Tax Exemption was not satisfied, and he denied the registration for the assessment year 97-98 and assessment year 2011-12. When this matter came to the tribunal allowed the appeal of the assessee. Now the department was in the appeal before the Orissa High Court. When this matter came to the Orissa High Court, the Orissa High Court said that according to section 12AA subsection 1 clause B and other provisions of registration and cancellation of registration under section 12AA, the Commissioner of Income Tax Exemption has power to review both the purpose and the activity of the society, both at the time of the registration as well as when the Commissioner of Income Tax is considering any application from the purview of cancelling it. So it was very much clear that the Commissioner of Income Tax Exemption has the power to review the activities also. The court said that objects are not the purposes, but advancement of the object is the purpose. The court further said that the definition defines purpose in terms of an activity, meaning thereby that when the objects are actually implemented, they are converted into activity, and until and unless the objects are transformed into the activity, the registration cannot be granted to the assessee, meaning thereby that the Commissioner of Income Tax Exemption has due power with him to consider the activity also. So on this ground, the Orissa High Court denied the registration to the assessee which was allowed by the tribunal. Friends, in this case, my viewpoint is that if the society is new, then the Commissioner of Income Tax Exemption can review only the objects. But when the society is already working, 3 or 4 years have already passed, then the Commissioner of Income Tax Exemption has the power to review both the objects and both the activities of the society. So in the present case, because the society was very old, the matter was relating to the assessment year 97-98 and the matter has come before the purview of the Orissa High Court in 2023. So there was no denying the fact that the society was very old. So the Commissioner of Income Tax Exemption has every power to review the activity, and whatever the registration has been cancelled by him was as per law. This was the viewpoint of the Orissa High Court in the present case. At the end of this video, once again I am repeating the name of the case. The name of the case is Commissioner of Income Tax Exemption versus Orissa Cricket Association, and this case has been reported in 461 ITR at page number 382, and the date of the judgment is 13th July 2023. Thank you, friends.